Welcome to Mayor Brown's International Arbitration Across the Pond podcast. Each episode is designed to provide insight on legal issues and other matters affecting international arbitration in the UK, US and around the world. The podcast is presented by two of Mayor Brown's international arbitration partners, Kwadwo Sarkodie from the firm's London office and Charles Harris from the firm's Chicago office. You can subscribe to this podcast on all major podcasting platforms, as well as Mayor Brown's YouTube channel. We hope you enjoy the podcast.
Welcome to the 15th episode of our Across the Pond podcast, presented by Chucky Harris and myself, Kwadwo Sarkodie. Today, I'm delighted to be joined by a former colleague, George Fisher. He's a senior solicitor at SSE PLC, which is a multinational energy company headquartered in Scotland. George worked alongside myself in the London International Arbitration team here at Mayor Brown, but has now been at SSE for a year. We're looking forward to catching up with him today very much indeed. So George, welcome to the podcast.
Hello, and thank you very much for having me. It's a pleasure to be here.
And that's not all. We also have on hand our partner, Kirsti Massie, working alongside me here in the London office at Mayor Brown as one of my partners here. She has a host of experience in relation to the renewables sector. Welcome, Kirsti.
Hi, great to be here.
Those of you who followed our last episode will recall that it focused on climate change and investment treaty arbitration. And during that episode, we spoke with our partner, Rachel O'Grady, who discussed the importance of combating climate change and the interplay that there is between climate change and the investment treaty legal framework. Now, that was an incredibly interesting legal discussion. And one of the key takeaways from that was the increasing urgency of action needed to combat climate change and how this actually has a number of implications in the international arbitration space. So following on from that, in today's episode, we're going to develop that theme somewhat further, exploring further issues, again, with a focus on the renewables sector. In particular, what we plan to do is explore with George and Kirsti both the growth of the renewables industry, project risks and potential disputes which may arise in that sector, and also why international arbitration is likely to be a primary method for resolving those disputes. We'll then delve a little deeper into the nature of arbitrations in this sector before looking to try and predict some of the future trends which may emerge in this interesting area where international arbitration deals with renewables disputes.
And I'm here too, by the way. So, let me just speak to everybody and say hello and welcome George and welcome Kirsti to this platform. We're happy to have you. So I think that the way we want to start off, so George, I'm really eager to learn more about SSE, what SSE does, and your role within the business. And I believe you're the litigation lead for the Dogger Bank offshore wind farm project, if I got that right, which sounds very interesting. So I'd like to hear a little bit more about it from you, if I can. Thanks.
Yeah, many thanks, Chucky. Yeah, it's been a real pleasure working at SSE. So for the listeners across the pond who might not have heard of them, SSE are the UK leader in investment in renewable energy. And I can safely say that we're all true believers in the importance and the urgency of the drive to net zero. So you may have seen that the relatively recent announcement from SSE PLC that following our sponsorship of COP26, that we're going to invest over £12.5 billion of capital in a plan to accelerate our progress towards net zero. That's not just offshore wind, but it's also investment into pumped hydro storage, transmission improvements, carbon capture and storage, and things like that. And there's a real recognition within the organisation that the drive to net zero is a multifaceted picture, and there's no single solution. So we're trying to invest across the board. But one of the flagship projects in this drive is the project to which, as you mentioned, Chucky, I'm involved with which is the Dogger Bank offshore wind farm project in the North Sea. This is offshore and it's being developed in 3 phases. And I think that one of the key features and key challenges for us is that it's a long way offshore. Go and look it up after you listen to this, but it's right in the middle of the North Sea, so it's further out than previous developments. And then when these 3 phases are complete, they collectively will be the world's largest offshore wind farm with an installed capacity of 3.6 gigawatts, and it'll be capable of powering up to 6 million homes. So that's pretty cool for the renewable geeks. And my role personally is to assist in the management and avoidance of disputes and as and when they occur, and to sort of be involved with the project management and the discussions with contractors.
Okay, so wow, it sounds like a very interesting project, but more importantly, of course, we are here to talk about international arbitration. So it sounds like you're the perfect person to have that discussion with.
Yeah, so hopefully it can be helpful.
Yeah, so I'm sure you can. So let's move a little bit and talk about the growth of renewables. So it's widely reported that renewables industry is going at an exceptional rate, as you probably know, George. For instance, just to give a couple examples, in December of 2021, the International Energy Agency reported that 290 gigawatts of new renewable capacity was installed worldwide, which is 90% up from the 2015 level. And to give just another example, global investment in renewables capacity also rose from, I think, is it 262 million to 362 billion across the same period? So why do you think the renewable industry is growing so rapidly, George?
Well, it's a fascinating question. I think there's 2 key reasons for the rapid development of the renewables industry. I think firstly, and perhaps most importantly, is the rising pressure from the general public for action on climate change. So from rising sea levels to more frequent and intense extreme weather events, the impacts of climate change are having and will continue to have devastating socioeconomic and environmental consequences. And since the overwhelming consensus of the scientific community is that human-caused greenhouse gases is responsible for climate change, it's clear that the decarbonisation of the energy industry is critical for combating climate change. And although less dirty fossil fuels, such as natural gas, will be critical to transitioning to a low-carbon economy in the short term, and SSE recognise that within our strategy, the renewable energy sources will be key to achieving the transition in the medium to longer term. And the majority of the public recognise this and are demanding action from legislatures, corporates, and increasingly from financial institutions too.
Okay, so absolutely. So has this growth impacted investors investing in renewable energy?
Yeah, the growing public pressure has meant that I think that institutional investors are becoming increasingly aware of climate risk as well. So now more than ever, there is growing awareness amongst investors of all sizes of the need to consider the climate crisis and the energy transition when deploying capital. And as a result, there's been a significant uptick in investor interest in renewable energy development. And then the second reason for the rapid growth of this sector, return to your question, is that the cost of renewable energy has fallen sharply over the last decade. And that's been driven by the development of technologies and economies of scale and growing developer experience and the widespread adoption of publicly stated government targets and the development of regulatory frameworks as well, aimed at supporting the deployment of renewables. So they've all come together and created a more sort of conducive environment for developers to move in. And consequently, renewable power generation technologies have become an increasingly low-cost option for new energy capacity for many regions across the world. And then together, these key drivers have resulted in the rapid expansion of the renewable sector as both the importance of tackling climate change and sophistication of technologies will only increase. The development of the renewables industry is likely to continue on its current trajectory.
So thanks, George. That's very, very helpful context. Clearly, to meet the increasing renewable energy needs worldwide, there will be a substantial investment in new renewable energy projects and existing infrastructure. In fact, I've just read our firm's U.S. offshore wind development 2021 year 2021 year in review, and it strikes me that the U.S. offshore wind industry also had a landmark year last year, and that trajectory is set to continue with the Biden administration being very supportive of offshore wind projects. So excellent as they may be, these substantial investments carry with them significant commensurate risk of disputes arising in relation to these projects. So I'll turn it over to Kwadwo now to talk about those disputes.
Thanks very much indeed, Chucky, because I see that as very important, because much like any other energy or infrastructure project, renewable energy projects will involve significant upfront investment, valuable intellectual property, complex regulatory issues, all of which, perhaps unfortunately, are perfect ingredients for disputes. So that's added to perhaps by factors such as the fact that joint venture arrangements are common in relation to renewable energy projects, necessary, of course, to bring together the requisite expertise, backgrounds and experience of different entities to bring to these very challenging projects. But it also brings potentially differing requirements and perspectives and different interests, which again can be a precursor for disputes. So George, in your experience, what do you find are the main risks associated with renewable energy projects, and what type of disputes are those that you see as most important to guard against?
Yeah, well, thanks, Kwadwo. Well, like you say, there are a variety of risks associated with renewable energy projects. And similar to other energy projects, disputes can arise in relation to these risks at any stage of the project, from the initial concept phase through the design engineering, construction, operational, then right up to execution and decommissioning phases. So I'm happy to elaborate on some of that. I mean, given the large upfront costs and technical expertise required, large renewable energy projects are, as you say, often multinational. This is both on the developer side with joint ventures such as we have on the Dogger Bank project, but also on the contractor too, and even on the lender side. So this adds a certain complexity both in applicable law and appropriate forum, but also in business culture, and it's something that has to be recognised and well managed from the very beginning of the project, by way of clear and efficient communication primarily. It's also why I believe, as we'll discuss, that arbitration is the standard dispute resolution mechanism for these kinds of projects.
Thank you very much, George. Yes, complex transnational relationships, definitely something that we have plenty of experience with in dealing with in our day-to-day practice, and indeed what you and I used to work together on when we were colleagues here at Mayor Brown. Yeah. So maybe if we get some time, I'll pick your brain further on that later. But in terms of other risks, are there risks that arise specifically from the new technologies which are associated with renewable power?
Yes, definitely. Offshore wind projects are particularly exposed to the adoption of new and developing technologies. Renewable energy projects to varying degrees seek to operationalize new technologies, and sometimes these can be on an untested scale. And that obviously then increases the risk profile, because unforeseen technical issues can arise both during the design and then the operational phases of the project. And then technical issues may become particularly prevalent as the number of floating offshore wind projects continue to rise, which is exemplified by the fact that floating projects account for approximately 60% of the latest ScotWind round. And yet floating offshore wind projects, which are based on floating structures rather than fixed structures, for those who don't know, require dynamic cables that can withstand impairments such as the continuous movements of the turbines and adverse weather conditions. The industry has already seen a considerable number of disputes arising out of the performance of electric cables used for fixed wind projects, which are simpler than the dynamic cables. So I think it's fair to say that this rise in floating offshore wind projects will likely result in an increased prevalence of technical issues. That's just one example I can think of. And then such technical issues can also result in claims of misrepresentation and negligence and breach of contract, where technologies fail to perform to expectations. And the really famous example of that, certainly in the UK, is the 2017 case of Hogard and E.ON Climate and Renewables, which where the contractor was found by the Supreme Court ultimately to be liable for breaching a contractual warranty following the miscalculation of the strength of a wind turbine's foundations, and thereby kept most of the London legal market on the dispute side for a number of years. So and let's not also forget that IP and other licensing disputes may follow from the use of proprietary technology as well.
Thanks a lot, George. So yes, that Hogard case certainly generated a lot of interest. What other sorts of construction issues do you see that arise?
Well, in terms of the construction phase, it's like any other construction project. We're likely to see the usual delay claims, and they can be caused by several factors, some of which are again common for construction projects, and some of which are specific to offshore projects such as ours. And that includes unexpected ground conditions, particularly for offshore wind projects where the nature of the seabed can be unpredictable, and then material shortages, supply chain issues, adverse weather conditions, they all come into play. And then cost overruns and claims for additional payments also frequently arise, as do your usual claims for defects, differences regarding the scope of works, and disputes over the responsibility for the design and performance of the works as well. So all of these factors give rise to the risk of disputes arising during the construction phase, as they do in any construction project.
I think if I could jump in here, I think that's sort of really interesting to hear the delay and risks around delay with a renewable energy project. I think for me, there's just one other thing to perhaps think about and add in here, and that's delays you might see in terms of grid integration. Because I think we need to bear in mind that what we've got in the case of renewable energy projects is the connection of intermittent power generation into a grid system that quite often in many jurisdictions was designed to essentially accommodate baseload dispatchable generation. And so there are real grid connection and grid reinforcement issues that need to be considered quite carefully. I think also when it comes to the grid, you may actually have a slightly different regulatory regime applicable to grid and grid connection than the regulatory regime that applies to the development of the generating project itself. That's certainly the case in the UK, where you've got the OFTO, the offshore transmission regime that's applicable to offshore transmission connection. So all of this needs to be factored into your project development. And therefore, I think when it comes to grid connection, there can be real sort of delays, both in terms of regulatory processes, difficulties in obtaining modelling information that's needed in order for you to properly design your project and connect to the grid. There might be delays in the grid infrastructure construction itself. And then, of course, you might also have power utilities who are also looking to modify or upgrade their equipment. The other thing just to mention here, and it's something we've seen in the UK, is an increase in environmental issues around grid connection. We've got a lot of renewable, particularly offshore wind projects connecting into the grid. And in the UK, we've seen a number of disputes around the cumulative impact that arises in the environmental context in terms of connecting large numbers of offshore wind projects onshore. So it's the onshore grid connection component that interestingly has raised the issue in the environmental context. So stakeholder engagement, I think, is really key in renewable energy projects, particularly in the offshore space. because you need to get those stakeholders on board to reduce and mitigate the risk of delay and the time and cost consequences that can arise as a result.
Thank you very much indeed, Kirsti. So this is creating an extremely useful picture of the variety of kinds of disputes which might arise, and they definitely don't sound like simple disputes in most cases.
No, definitely, Kwadwo. And the examples I've given are by no means an exhaustive view of every project-specific risk either. And I think other disputes which may arise are in relation to areas such as warranties and product liability, as well as post-M&A issues too.
So as we've discussed, there's clearly a number of project-specific risks, and it seems like practitioners will be able to use their knowledge and experience gained from working on non-renewable energy projects when attempting to mitigate some of these risks. So moving beyond these project-specific risks then, are there any risks relevant to renewable energies from a regulatory perspective, George?
Well, definitely. I have to say that the UK is generally pretty good on this front. So it's not, unfortunately, it's not something that I've had to consider myself, particularly personally. But you're correct that there can be a heightened degree of regulatory and political risk in relation to renewable energy projects in other jurisdictions. So to ensure consistency with low carbon policy objectives, many jurisdictions have introduced favourable regulatory frameworks that are designed to encourage investment in renewable energy. And since government incentives generally have criteria for eligibility, disputes may crop up in relation to the monitoring, reporting, and verification of those obligations.
Yeah, and I think it's also interesting to think about what happens when some of these regulatory regimes are fundamentally altered, or in fact, they can actually be cancelled completely, because then you find yourself in a situation where the underlying economic value of the project, of the renewable project, is really reduced. And it's fair to say that these sorts of things are not unheard of. You may have a change in the regulatory regime because of the decreasing cost in the new technologies over time. So governments or regulators may take the view that the continuing support is no longer needed for a particular type of technology. Or it may be as a result of financial circumstances, which is something that happened in following the 2008 financial crisis, where several European countries retroactively reduced the financial support that they were going to provide to investors in solar PV projects. So states that made such changes found themselves defending claims from investors, whether that was under investment treaties or pursuant to contractual stabilisation clauses. And I think it's also worth noting again that we've seen in the UK issues with permitting and litigation around the granting of licenses by BEIS, such that a license that was granted was then withdrawn on the basis that the process that BEIS themselves had followed and the information they considered was not perhaps as robust as it should have been. Now, that kind of withdrawal of a license has a real serious implication for a developer who may have incurred significant development costs up until that point. And I think it's also worth bearing in mind that regulatory regimes can be subject to state aid review. We've seen that in the UK in the context of the capacity market, where that kind of review resulted in a suspension of the market, which again caused real issues for project developers, owners and operators, and also their lenders.
Thank you, Kirsti. So we'll come back to the investment treaty matters in a bit, but let's complete the list of risk. Is there anything else you wanted to mention?
Yes, I think another risk arises from the sort of contractual uncertainties that arise. There's a real lack of industry standard form documentation in terms of EPC arrangements, but also other project documents. So whilst you may have certain classic mechanisms for supporting a project, whether that's a feed-in tariff type arrangement or a contract for difference, what I find interesting is that there's no real industry universally adopted standard in terms of the contractual documentation. And therefore, this gives rise to a real risk that contractual counterparties have different views as to what their understanding of the various contractual rights are. And that was demonstrated in the Hogard case, which George mentioned earlier. In the solar industry space, we've seen some interesting developments in that there's been an attempt, a couple of initiatives actually, to try to standardize some of the solar power contracts in solar projects. So a bit like the FIDIC approach to the construction industry. And that standardization was really an attempt on the part of solar power industry stakeholders to try and mitigate some of the risks and reduce delays, I think, as well. So in June 2019, the Terawatt Initiative and IRENA, so that's the International Renewable Energy Agency, created the open solar contracts. And the hope there was that those solar contracts would be the sort of standard form of contracting for small and medium-sized grid-connected solar PV projects. I was actually involved in drafting some of those standardized contracts. But before the IRENA and TWI initiative, there was the IFC Scaling Solar Programme, again, which was aimed at developing a robust public-private partnership model for a single deal and then replicating that across other deals. I think it's fair to say that the IFC Scaling Solar Programme has had greater uptake so far than the open solar contracts documentation. But again, it's been around for a bit longer, so that may explain it. But whilst standardization can be a real positive, it's worth bearing in mind that there can be some downsides, because in my experience, it's led to a number of governments expecting a continued reduction in the price per megawatt for renewable power. And this has led to a real squeeze on developers, and actually has resulted, I think, in some reluctance on the part of developers in bidding for certain solar programs. So I think it will be interesting to see what happens in terms of the uptake of the open solar contracts and the scaling solar program going forward, and see what happens over the years to come. But I think that really what we're seeing is that if these project risks are not properly managed, if they're not dealt with properly in the contractual arrangements, then you've got a whole variety of parties that could find themselves involved in disputes, including companies involved in the development and operation and maintenance of the projects, in terms of their underlying technology, but also the investors who are involved in the financing of the projects may become involved in disputes. And of course, the states where the projects themselves are located.
Wow, thank you so much, Kirsti. It was great to have such a detailed and comprehensive summary of the various risks and issues which can be associated with renewable projects. And what it's really driven home for me is that project stakeholders can find themselves potentially embroiled in complex cross-border issues which involve multiplicity of evolving laws, perhaps laws of different jurisdictions, with regulations which develop with business cultures and governmental cultures which perhaps diverge or may not sit entirely neatly with one another. And I think all of this means that the effective management of potential and indeed actual disputes is going to be crucial. So that brings us now to our favourite subject, international arbitration. And George, it would be great to have your perspective on whether you think that international arbitration is an appropriate means by which to resolve and address disputes arising in the renewable energy project industry.
Well, absolutely. I think there's no doubt that international arbitration will be the natural choice for resolving these kinds of disputes, and should be. It should be the primary method to keep the energy transition on track.
Well, thanks a lot, George. That's the right answer, and it's what we wanted to hear on this podcast. Yeah. But can you share a bit more about why exactly it is that you think that international arbitration is so particularly well suited to renewables disputes?
Yeah, I mean, it's hard to put your finger on the prime reason, but if I was going to choose one, it would be that, as we've mentioned previously, that this is primarily involving cross-border transactions, and by their very nature, cross-border disputes lead to more complex and unique situations. So international arbitration is a really effective way of resolving those kind of disputes. And I think it was QMUL's 2020 survey speaks volumes in that regard, since 90% of respondents preferred international arbitration for resolving cross-border disputes.
Thank you very much, George. And why is it you think that might particularly be the case?
Well, the first thing to highlight is that arbitration provides parties with a neutral forum. So, that's key in the context of international disputes, where parties originate from different jurisdictions, and they may not trust their counterparty's home court system. So instead, they can therefore pick a seat and physical hearing location that's different from their party's nationalities. And then I think moving on from that, there's the very robust enforcement regime that we're given by the New York Convention. And that's another key reason that energy stakeholders opt for arbitration. So with almost 90% of the world's states being a part of the convention, they can have added assurance that there's a route by which they can seek to enforce their awards in jurisdictions around the world where relevant assets are located. And in fact, that can actually be a quicker enforcement than trying to enforce a court decision. So there's no comparable treaty for judgments, and inevitably that means that arbitration is relatively more easy to enforce than enforcing court judgment. And then I think the other benefits of arbitration include the ability to choose decision makers themselves with specialized expertise. And that's especially, we're talking above about the technical issues that can arise on offshore and renewable projects, and the technical and scientific expertise and industry specific knowledge that the parties can bring to proceedings by selecting their own arbitrators gives extra comfort. And then also confidentiality, and that might be paramount where, for example, trade or commercial secrets in emerging technologies risk being exposed as part of a dispute. And this privacy can also assist in preserving ongoing commercial relationships, something that's particularly important in the renewable industry, where there's a relatively small pool of industry players, and long-term relationships between companies is actually quite important.
So George, just quickly picking up on your point about the parties nominating their own arbitrators. So this really allows the parties to be in control of the process. And in my view, it'll be crucial for renewable stakeholders, as they will no doubt be looking to find arbitrators who know the industry and the precise subject matter in the dispute.
Exactly, and let's not forget that arbitration offers procedural flexibility. So arbitrators can adapt the process with that flexibility, and many arbitral rules provide for smaller value disputes to be resolved using expedited procedures, and that could mean that arbitration could be faster and more efficient than litigation. So there's generally also no right of appeal from an arbitral award. And therefore, save for limited recourse to have an award set aside for enforcement denied, the outcome can be considered relatively final. And then the finality of arbitral awards can also therefore reduce time and costs in resolving disputes. So these considerations are likely to be important to many stakeholders, but are particularly relevant to emerging market companies.
Thanks, George. So one other point which I'd like to pick up on from our earlier discussion, and that's the nature of renewables projects being such that they often involve multiple parties and multiple related contracts. How can arbitration and can arbitration help in that regard? So
most international arbitration institutions like the ICC, LCIA, AAA, etc., they account for multi-party arbitration in their rules in terms of each party being treated fairly during the process of arbitrator selection. And they also provide procedures such as joinder and intervention. And regardless of the rules, parties are also always free to provide for such issues in their arbitration clause, so as to address what will happen in multi-party situations. And then finally, when it comes to multiple related contracts, there's scope to consolidate the arbitration cases, either pursuant to the parties' agreed requirements in their arbitration agreement, or under the terms of the institutional rules that they've selected to apply. So this really allows the parties to avoid the danger of having competing tribunals, which are obviously naturally very expensive, but also risk generating inconsistent awards. So although I've just outlined some of the main reasons why arbitration is the appropriate forum for resolving disputes arising out of renewable energy projects, I just want to draw listeners' attention to the fact that I know the ICC Commission has commissioned a report titled Resolving Climate Change Related Disputes Through Arbitration and ADR. And this report explores in much more detail why arbitration is an appropriate forum. So yeah, your listeners should have a read of that if they're interested.
Thanks so much, George. That is really useful to know. So we all know that the energy sector is one of the most featured players in international arbitration, and some of the highest arbitration awards handed down in history have been associated with energy-related arbitrations. In that regard, we've seen investment treaty arbitrations under the Energy Charter Treaty and bilateral investment treaties and so on. And often we see those claims being founded on the basis of either alleged breaches of fair and equitable treatment or allegations with regard to expropriation. So Kirsti, what I'd be interested to hear is how many arbitrations in that sector relate to renewables? Is that something that you've been able to get an impression of?
Yes, so I did a little bit of digging around and found that as of October 2020, there were 80 investment disputes under the ECT, the Energy Charter Treaty, that concerned renewable energy sources. And so clearly that figure will be higher as of today. Now, included within those 80 disputes were a number of solar cases against Spain. As we spoke about a little bit earlier, following the 2008 financial crisis, that prompted some regulators to change, or governments to change, the regulatory support that was offered to renewable projects. And that certainly was the case in Spain. So in 2007, Spain introduced a feed-in tariff to try to attract investment in renewable energy sectors. And what that support mechanism did, that feed-in tariff did, was to offer producers of energy an above market price for the electricity that they delivered. Spain then later rolled this back and ultimately eliminated the tariff completely. And this resulted in over 50 claims being brought against Spain, mainly by investors in the solar PV generation sector. And those generators were claiming, amongst other things, that the regulatory measures amounted to an indirect expropriation, and that Spain had failed to provide fair and equitable treatment as is required by the ECT. So Spain has actually prevailed in many of these cases, but not in all of them, with tribunals having found that the changes to Spain's renewable energy subsidies breached the ECT. And I think whilst claims concerning feed-in tariffs may well continue to come about, I think there's also a more recent development that's worth thinking about, and that concerns examples that we're seeing now of subsidy-free offshore wind and solar projects. Now, that's being introduced in a number of markets, including Germany and the Dutch market. And in these types of projects, the public investment incentives have effectively been replaced by long-term supply contracts with large utilities.
Thank you very much, Kirsti. That sounds like a particularly interesting development. So I think that's something we'll have to watch carefully. So I think that also nicely leads us on to the next stage of this podcast, which is something Chucky and I regularly like to look at, and that is future trends and developments with regard to arbitration, and particularly where those developments might be in relation to the renewable sector. So for this sector, I'd like to kick off with you, George, if I may, and ask what you think we will see with regard to the development of tailored model clauses and or specific arbitral rules, specifically for the issues which arise around renewables projects.
Well, that's a really interesting question, Kwadwo. I think it's likely that arbitral institutions will take positive steps to position themselves as forums to resolve disputes concerning renewable energy projects, given the suitability, as we discussed, of arbitration as a means to resolve these disputes. And institutions may therefore begin to offer model clauses and or tailored arbitration rules in respect of these specific disputes. And in my opinion, market pressure for tailored model clauses and arbitration rules will arise in the mid to long term, at least, rather than the short term, as we are likely to see that the demand lags slightly behind the uptake in the use of arbitration as the dispute resolution mechanism of choice. So, although I don't think we will see tailored clauses and rules for a good few years, I think that it's definitely possible that we'll begin to see them beyond that.
Thank you very much indeed, George. That's very interesting. And on a separate point, how about expedited arbitrations and provisions for accelerating the process? How relevant is this and how popular is it likely to be in the renewable space?
Well, in terms of expedited arbitration, it's clear that there's need to commence the operation of assets on time to ensure the financial viability of energy projects. And that's, I can say that is the key concern when developing these projects. And this need is particularly acute for renewable projects, given that it's often time-sensitive nature. And I anticipate that owners and operators will therefore increasingly focus on means to avoid lengthy delays caused by disputes on live projects. So consequently, expedited or fast-track arbitration is likely to become an increasingly important means of resolution, both for technical and more general project-related disputes, but basically to ensure that the project keeps going on track. In addition, many institutions now have expedited rules or procedures, the ICC, SIAC, and the ICDR, to name but a few. And then UNCTREL has also recently released the expedited UNCTREL rules, which would be suitable for ad hoc arbitrations. And these rules provide a comprehensive mechanism to facilitate the use of expedited arbitration. And interestingly, the latest draft of the ICSID rules, which are being put to a vote shortly, also contain the option to fast-track proceedings through new expedited arbitration rules. And given the nature of renewable disputes and the increasing availability of expedited procedures, I think we'll definitely see more reliance on the use of those expedited arbitration procedures and see that as a broad future trend.
So Kirsti, there's one question that I wanted to ask you before we wrap up today's session. We've touched on floating offshore wind sites, which I understand may be situated in the high seas. The disputes in relation to projects of this nature raise particular issues?
Yes, that's actually an interesting question, because the legal regulation of offshore wind farms in the high seas is currently quite problematic. The United Nations Convention on the Law of the Sea, so UNCLOS, generally governs the rights and obligations of states on the high seas. UNCLOS currently has 168 members, including the European Union, and it provides for arbitral procedures as part of its dispute resolution options. But due to a concept of freedom of the seas, a state cannot claim exclusivity for a specific part of the high seas. It's highly likely that an offshore wind farm that claims exclusive use over a large area in the high seas would conflict with the other members' rights to free use of the seas. And in addition, you have to think about the fact that private operators can only be granted rights to the extent that the member itself has such rights. So under the regime as it currently stands, states and private entities will find it really quite difficult to protect their ownership and jurisdiction. So I think there are two comments to be made in this respect. First, will these challenges themselves lead to arbitral disputes? Well, only time will tell. But secondly, I think it's likely that we'll start to see the development of additional regulation to address these problems, the right of use as well as ownership and jurisdiction. And many in the offshore wind industry are pushing for this to start as soon as possible. And if this is drafted within the United Nations sort of framework, which is most likely, then it may actually take really quite some years to complete.
Thank you for the wonderful insights, Kirsti and George. Thank you guys for being here. I think that what we can all take away from this episode is that despite the rapid growth in the global renewable energy industry in the past recent years, the industry is still at a relatively early stage. If global greenhouse gas emission reduction targets are to be met, the wind and solar power sector in particular must expand substantially from their current levels. Achieving that amount of cross-border investment required to effect this expansion will not be possible without the establishment of effective means of dispute resolution. International arbitration, both investor, state, and commercial, is becoming and will continue to become a key mechanism for resolving disputes related to renewable energy projects.
Thanks, Chucky. I couldn't agree more with that. And from what we've discussed with George and Kirsti in today's episodes, we've heard some really fascinating insights on those disputes. And I'd like to thank both guests. I think we couldn't have had two more knowledgeable people on this episode on this particular subject. So what really comes across to me is really this is a developing and indeed a maturing area. We've seen disputes in the past which have centered on issues such as subsidies and other support mechanisms. But what we're seeing, I think, is as green energy is really coming of age, the technology is developing, as George, as you explained, economies of scale are building by the year. And I think that is also going to drive and influence the nature of disputes, which is something I find very interesting. We're seeing the future of disputes in the renewables area, perhaps likely to expand away from subsidies and support and into the contractual commercial areas, which are inherent and sit between parties rather than between a government and an investor. But really, whatever the nature of the dispute, the impression I've really got from each of you, Kirsti and George, is that arbitration does provide an effective and efficient means of addressing those disputes and resolving them. So what we at Mayer Brown expect to see is a growth or continuing of the growth of the number of disputes in that area, and of parties putting together projects in this area having to consider arbitration from the outset, from the benefits that it really can offer. So thank you very, very much, both of you, for your insights on that.
Thank you.
Thank you very much.
Thank you.
Thank you, Chucky. Thank you, Kirsti, and thank you, George. It's been great to hear from all of you today, and thanks to all the listeners for joining us on this latest episode.
We hope you enjoyed this podcast. If you have any suggestions for topics or want to reach Kwadwo, Sarkodie, or Charles Harris, you can find them at the Mayer Brown website, mayerbrown.com. Also, to learn more about other Mayer Brown audio programs, please visit mayerbrown.com/podcasts. Thank you for listening.